This course with the establishment and mandate of the DLC. Article 162.2 of the Constitution mandated Parliament to establish courts of equal status of that of the High Court to deal with disputes relating to employment and labor, and the environment and the use, occupation of the entitled to land. I've quoted the provisions of Article 162. It's pursuant to these constitutional imperatives of parliaments, enacted the Environment and Court Act 2011, and provided the expanded jurisdiction of the courts. As already stated, the Constitution at Article 162 provides that the superior courts are the Supreme Court, the Court of Appeal, the High Court, and the courts referring in Clause 2. It's therefore clear from the aforesaid provisions of the Constitution that this court, just like the other four superior courts, is not only a creature of a statute, but also a creature of the Constitution. Indeed, in addition to the Environment and Court Act, the Constitution itself confers on the ELC the jurisdiction to determine disputes related to the environment and the use and occupation of entitled land. This position was affirmed by the Court of Appeal in Chineli, Changa case, which observed as follows. The Constitution has therefore created a specific court with equal status to the High Court and conferred on it the jurisdiction to hear and determine disputes relating to, among others, use, occupation, title to land, and any other dispute relating to land. But indeed, not only were the two specialized courts created by the Constitution, they were created as courts of equal status in the High Court. In Chimwili Changa case, the Court of Appeal held as follows. I quote, Article 165.5 of the Constitution provides an express terms that the High Court shall not have jurisdiction over matters falling within the jurisdiction of the Environment and Court. Again, by dint of Article 165.6 of the Constitution, the supervisory jurisdiction of the High Court does not extend to the ELC, which is a superior court like the High Court and Court. The position that the Environment and Land Court has the same status as the High Court or the Supreme Court in the Republic of Ascarisa Chengo as follows. I quote, in addressing the latter historical controversy, the Committee of Experts restated a provision allowing Parliament to establish by legislation employment in land-stroke environment courts with a status equivalent to the High Court, as had been provided for in the earliest drafts of the Constitution, including the 2005 referendum draft by the Constitution of Kenya Review Commission. The Committee of Experts, its final report, adverted to three main factors: securing anchorage in the Constitution for the specialized courts. These were first, setting out in broad terms the jurisdiction of the ELC as covering matters of land and environment, and the ELRC as covering matters of employment and labor relations, but leaving to the discretion of Parliament to elaborate on the limits of those jurisdictions in legislations. Secondly, and more fundamentally, the establishment of the ELC was inspired by the objective of specialization in land and environment matters, by requiring that ELC judges were, in addition to the general criteria for appointment as judges of the superior courts, to have some measure of experience in land and environment matters. Lastly, the Committee of Experts ensured the insertion in the Constitution of a statement of the status of the specialized courts as being equal to that of the High Court, obviously to stem the jurisdictional rivalry that had reported in experience between the High Court and the Industrial Court and Court. The Court stated further as follows, quote, Article 162.1 categorizes the ELC and ELRC among the superior courts, and it may be inferred then that the drafters of the Constitution intended to delineate the roles of ELC and ELRC for the purpose of achieving specialization and conferring equality of the status of the High Court and the new category of courts. Concurring with this view, the land judges of the Court of Appeal in the present matter observed that both the specialist courts are of equal rank and none has the jurisdiction to superintend, supervise, direct, shepherd, and or review the mistake, real or perceived of the other. Thus, a decision of the ELC or the ELRC cannot be the subject of appeal to the High Court, and none of these courts is subject to supervision or direction from another. The Supreme Court went ahead to say that the three courts are of the same juridical hierarchy and therefore are of equal footing and standing. To us, it simply means that the ELRC and ELC exercise the same powers as the High Courts in performance of its judicial function. It is specialized jurisdiction, but they are not the High Court, unquote. The key words in the Karisa Chengo case by the Supreme Court are that the Environment Land Court exercises the same powers as the High Court in performance of its judicial function in its specialized jurisdiction. On 30th of August 2011, Parliament established the Environment Land Court Act 2011, Section 13 thereof set out the jurisdiction of the court, which initially included supervisor mandate at Section 13.5. As follows, I quote, the court shall have supervisory jurisdiction over the subordinate courts, local tribunals, persons or authorities in accordance with Article 1656 of the Constitution, unquote. On 6th of July 2012, the Statute Miscellaneous Amendments Act of 2012 received the presidential assent. Under the Act, several laws were amended, including the Environment Land Court Act, relevant of which was the deletion of Section 13.5, which granted this court supervisory powers. It's not lost on this court that and the court takes indeed judicial notice of the fact that several provisions of the above-mentioned statute law Miscellaneous Amendment Act of 2012 have been declared unconstitutional by the courts. The court in Mercy Munekimo versus Safaricom found that the amendments to Section 30A of the Copyright Act to be unconstitutional, holding that not only was there no evidence that the stakeholders were engaged before the introduction of the said section, but the amendment was not minor. The same fate befell the amendments to the Law Society of Kenya Act through the same statute law Miscellaneous Act number 12, 2012, which were found to be unconstitutional by the Court of Appeal in Law Society of Kenya versus the AG. The appellate court struck down the challenged amendments and held that the legislature overreached in passing substantive amendments in a procedural and non-participatory manner. The legitimacy of the statute law Miscellaneous Amendment Act number 12 of 2012, which amended the ELC Act by deleting Section 13.5 of the Act, which provided for the court supervisory role, has thus been impugned by multiple courts, including the Court of Appeal. This is based on the fact that it makes substantive changes to the laws without the input of stakeholders. However, that's not an issue before me. So back to the matter at hand, the foundation of the applicant's objection is the deletion of Section 13.5 of the ELC Act, which provided for the supervisory jurisdiction of the court. So what is supervisory jurisdiction? The Black's Law Dictionary defines that the control exercised by a higher authority over a lower court as by prohibiting the lower court from acting extra-jurisdictionally and by reversing its extra-jurisdictional acts. The question that arises from this definition is whether superior courts such as the Environment Land Court can exist without supervisory power over the subordinate courts, the tribunals dealing with environment and land matters, because the law does not expressly state so. It has been submitted by the applicants that it's only the High Court, pursuant to Article 165.6 of the Constitution, that has the mandate to exercise supervisory jurisdiction over the subordinate courts and that pursuant to Article 165.7 has the authority to call for the record of any proceedings before the subordinate court, person, body, or authority referred to in Clause 6 and make any order or give any direction it considers appropriate to ensure the fair administration of justice. Article 165 of the Constitution lays down the general jurisdiction of the High Court. Article 165(5) of the Constitution provides that the High Court shall not have jurisdiction in respect to matters falling within the jurisdiction contemplated in Article 162(2) of the Constitution. As subsequently espoused by Maganda J. in the United States International University by the Attorney General, the jurisdiction bestowed upon the High Court under Article 165(3) is not absolute but subject to Clause 5. Most provisions forbid the High Court from exercising jurisdiction over matters falling within the province of the Supreme Court and the specialized courts established under Article 162(2). In the United States International University case, the court observed that the jurisdiction of the specialist courts is to be determined from a textual consideration of the provisions governing the judicature. The court observed that the High Court cannot exercise jurisdiction in matters reserved for courts of equal status contemplated under Article 162(2) of the Constitution. Article 259 of the Constitution demands that the Constitution be interpreted in a manner that promotes its purposes, values, and principles, advances the rule of law and human rights and fundamental freedoms in the Bill of Rights, permits the development of the law, and contributes to good governance. It also demands that every provision of the Constitution shall be construed according to the doctrine of interpretation that allows others speaking. In the case of the matter of interim independent electoral commission, the Supreme Court affirmed that the Constitution must be purposively interpreted, stating as follows, I quote, "The Constitution of a nation is not simply a statute which mechanically defines the structures of government and relationship between the government and the governed. It is an order reflecting the national soul, the identification of ideals and aspirations of a nation, the articulation of the values, bonding its people and disciplining its government. The spirit and the tenor of the community must therefore preside and permeate the processes of judicial interpretation." The Constitution has to be interpreted purposefully to avoid austerity of tabulated legalism. And quote, a superior court, this court has appellate jurisdiction over the magistrates who have been gazetted to handle land matters, as well as multiple tribunals, including the National Environment Tribunal, the Business Premises and Rent Tribunal, Water Tribunal, and the Cooperative Tribunal. Taking into account the applicant's arguments, are we then to say that when these subordinate courts and tribunals, which are answerable to the ELC on appeal, step outside their mandate, it's the High Court that has the jurisdiction by dint of Article 165, 6, and 7 of the Constitution to intervene? What then becomes of these courts and tribunals? Are they left unchecked if the High Court has no jurisdiction to supervise them? This court has had the occasion to address the question. It's to be noted that this court exercises judicial review jurisdiction in matters pertaining to environment and land, through which the court essentially supervises the proceedings and decisions of the lower courts, tribunals, and other bodies that perform public functions. As expressed by the court in the Republic by the Speaker of the Senate, the court decisions should recognize the Constitution as the base for judicial review. Judicial review is now a constitutional supervision of public authorities involving a challenge the legal validity of the decision and court. If we are to take the position that this court does not have supervisory jurisdiction over the subordinate courts and tribunals, it will essentially mean that the court is bereft of judicial review jurisdiction. This court has had the occasion to address the question with respect to its powers in Joyce Matindi. While sitting in Machakos, this court held as follows, I quote, if the court has the jurisdiction to exercise the appellate jurisdiction of the decisions of subordinate courts and tribunals, and consider that the court has the same constitutional status as the High Court, It follows that the court has a supervisory role over such subordinate courts and tribunals. It does not matter that the law does not expressly state so, or that the provision of the law states that the court has such supervisory role was led by Act number 12 of 2012 and court. Similarly, National Social Security Fund, Okomo J, in considering whether the Environment Land Court exercises supervisory jurisdiction over subordinate courts, stated as follows, I quote, it's common ground that this court has supervisory jurisdiction over the magistrate's court in respect of matters falling within its jurisdiction. I'm of the view that this court will be abetting an injustice against the applicant and undermine proper administration of justice if it fails to intervene in this matter, unquote. The applicants have referred this court to several cases, key of which is the Patrick Musimba case, which the court has considered. In that case, the High Court considered whether, in light of the amendment of the ELC Act, Parliament took away the court's jurisdiction determining matters of constitutional nature involving environment and land generally. The court stated as follows, I quote, in view of the 2012 amendments to the ELC Act, one would be tempted to conclude that on a true construction of Section 13(3) of the ELC Act, the jurisdiction of the ELC, insofar as enforcement of constitutional rights was concerned, was limited and restricted by Parliament to matters related to a clean and healthy environment under Article 42, 69, and 70, and not environment and land generally under Article 40 of the Constitution. The Court of Appeal decision in Angote, as read together with Section 13 of the ELC Act, however, lead to the plausible conclusion that the ELC has jurisdiction determining matters of a constitutional nature as well. We also say so, as it would be ridiculous and fundamentally wrong, in our view, for any court to adopt as a rationalist view or approach and insist on splitting issues between the courts where a court is properly seized with a matter but a constitutional issue not within its obvious express jurisdiction is raised. And quote, while it is apparent the High Court in Patrick Musimba case was not dealing with and therefore did not interrogate the question of this court's supervisory role, the court appreciated the need for a holistic interpretation of the Constitution in light of the court's jurisdiction. Indeed, the High Court in the Patrick Musimba case did not say that the ELC does not have supervisory role over the subordinate court. Rather, the court frowned upon the adoption of a separationist view or approach in the splitting of issues between the courts where a court is properly seized with a matter, which is the very act that the applicants are doing. The Constitution having granted this court the status of the High Court in matters relating to environment and land, and without resorting to tabulated legalism, it follows that powers of the High Court to supervise subordinate courts under them applies mutatis mutandis to this court, but limited to environment and land disputes. In conclusion, it's the finding of this court that supervisory jurisdiction refers to the power of superior courts of general superintendence over all subordinate courts. Through supervisory jurisdiction, superior courts aim to keep subordinate courts within their prescribed sphere and prevent usurpation. The supervisory power over the lower courts by the superior court is sui generis jurisdiction, anchored or rather accorded to superior courts through which they keep checks on subordinate courts and tribunals. Consider the High Court cannot superintend over subordinate courts gazetted under the Environment Land Court Act to handle environment land disputes, and the Environment and Land Court being of the same status as the High Court, it follows that the court has supervisory jurisdiction over those courts, notwithstanding the Environment Land Court Act does not expressly state so. In the end, it's the finding of the court that it's duly vested with supervisory jurisdiction. The applicants have followed the court for its reliance on the provisions of Section 3 and 18(1)(b) of the Civil Procedure Act 2010. I have to produce the Section 18(1)(b). Having held that the status of this court is similar to that of the High Court, and considering that the Environment Land Court was not in existence at the time of the commencement of the Act, it follows that The word High Court in the Civil Procedure Act should be interpreted to mean environment and land court, wherever the court exercises its constitutional mandate. This is in line with Article 262 of the Constitutional Schedule, which provides as follows: quote, all law in force immediately before the effective date continues in force and shall be construed with the alterations, adaptations, qualifications, and exceptions necessary to bring it into conformity with this Constitution, unquote. Taking into account the foregoing and noting the provisions of Section 19 of the Environment Land Court Act, which provides that the court shall be bound by the procedure laid down in the Civil Procedure Act, and having found that this court has provided jurisdiction over the subordinate courts, this court will now consider whether it exercises its authority lawfully. In Republic versus Chief Magistrate's Court, ex-court Bradley Galot, the High Court distinguished supervisory jurisdiction as against appellate jurisdiction and held that it ought to be used only in circumstances of grave miscarriage of justice. I will produce that quotation. The record in this matter shows that after the lower court issued orders of injunction in Magistrate's Court ELC number E361 of 2022, the nation moved in Mara as the occupants in a building standing on LR number 1870, Stockholm 3/46 in Westlands, Nairobi, were violently evicted and the house demolished on the basis of an order issued by the principal magistrate. The newspapers and the TV stations published two orders purportedly issued by the subordinate court, which orders appear to be at variance with each other. Other than the purportedly conflicting orders, the question that arose was whether the magistrate who issued the order that was used to evict the occupants of the house and demolish the house had peculiar jurisdiction to issue those orders in the first place. So that based that this court exercised supervisory jurisdiction on its own motion and transmitted the lower court file to the court pursuant to the provisions of Section 18(1)(b). On 9th of November 2022, the court directed the advocate who had extorted the orders of the court and the auctioneer who executed the said orders to file an affidavit to explain the circumstances under which the order by the lower court were used to evict the occupants in the property and the demolition of the house. This was in light of the express orders of the lower court that prohibited the respondent from interpreting the injunction order to meet eviction. Considering the circumstances enumerated above, this court is persuaded that the circumstances of the case involves severe miscarriage of justice and flagrant abuse of the principles and rule of law, which require the intervention and further inquiry by this court in its supervisory role of the magistrates gazetted to resolve disputes relating to land and environment. The applicants have sought to impugn the contempt proceedings. Hearing they contend that first, the court are not obliged to undertake the contempt proceedings hearing, and second, that the auctioneer was not accorded the right to a fair hearing before being convicted for contempt. I've quoted the Blackstone Dictionary on what contempt entails, and I'll just repeat it. What contempt is conduct that defies the authority or dignity of a court, because such conduct interferes with the administration of justice. It's punishable usually by fine or imprisonment, unquote. I've quoted several positions from what contempt is all about. The law that governs contempt of court proceedings is the English law applicable in England at the time that the contempt is committed. And